Okay, Mr. and Mrs. Weitzel, are you on now? Oh, they're connecting to the audio. I apologize for the delay. And Matt is having a hard time with audio.
This is Joel Weitzel. To let people know, it's like our neighborhood has been without power for the last hour.
Oh dear.
So, I mean, I'm connecting through my phone, but my phone isn't fully charged.
Oh dear. See. Mr. and Mrs. Raleigh, do you have power there?
We actually relocated when the power went out so that we could join.
All right. Well, Chair, do you have any, there's no way for you to charge your phone, Mr. Weitzel? Are you able to get a charger for your phone?
No, ma'am. It said it requires a power supply.
Ms. Huber, do you have any suggestions?
Mr. Weitzel, how much charge do you have? Can we try to move this along as quick as we can? Is that feasible, or do you have like 2% and that's not even an option?
That's not an option.
Okay, can you think of a way to get yourself to somewhere where you can charge your phone? I mean, is there somewhere you can go that you would have power? And we could sort of wait for 15 minutes for you to get there?
No.
As far as we can tell from consult with neighbors, this whole area is without power.
Would it be possible to use a car charger from a car, like sit in the car so we could move forward with this?
That's really uncomfortable and kind of unreasonable. I mean, you guys moved.
Yes, we did as soon as the power went out.
So the BZA's rules of procedure provide that in the event that and I'm just saying this to get everyone on, so everyone knows the information that I have. The rules of procedure say that in the absence, well, it says the failure of the applicant or petitioner, so that's the Weitzels, or their authorized representative to attend the hearing shall result in the board proceeding to conduct the hearing in his or her absence. So that's what I have on the one end. Obviously, I'm completely sympathetic to the fact that a power outage has occurred, which is no one's doing. But I don't think it's unreasonable of us in trying to work with you, Mr. and Mrs. Weitzel, to see if, for you at least to engage in the conversation of whether there's an alternative. I mean, can you really not think of a possibility of, I mean, how much charge are we talking? And is the phone the only device you can use? And if so, I totally understand that.
We can't use our laptops or computers and now.
So do you have a car charger where you would be able to go sit in the car to continue this meeting?
I still think that's unreasonable.
Well, my question is, are you you have that available so that this meeting can be continued tonight?
Or do they wish to participate with the meeting? We have all of the information in writing.
No,
No, you don't. You have art. Okay, so we submitted.
Okay, so before we get into any of that, just help us help you. What is a way that you can think, I mean, if you don't like, I mean, I mean no disrespect. If you don't like our ideas, do you have a feasible alternative that would work for you right now?
He's muted.
I just asked him to unmute. I can't do it for him, unfortunately.
We'll go outside. I'll see what I can find.
Yeah.
Yeah. They have their attorney on.
Would it be possible for us to have the other parts of the meeting? No?
Tom, I'm sorry.
Well, anything's possible, but there's not a whole lot to cover, and I really think we ought to see which way they're going to go on this. I don't think they legally have to participate, do they?
No, like I said, your rules provide that if they're absent, the hearing will continue without them. It's not a
Right.
rubber stamp one way or the other, but it can continue without them. But if they'd like to be present, then it sounds like they're
Well,
working on being present.
My feeling is that we'll continue. I think let's give them another 5 minutes, and if that doesn't materialize, then I'll call the meeting to order.
Understood.
Okay.
All right, thank you. We're in our car. We have it running.
Appreciate your help with that.
Yes, thanks.
Okay, well, at this point, I'm going to call the hearing to order. It's 6:45 p.m. on August 11th. And we're conducting this via virtual public hearing per Ohio House Bill 197 via Zoom. And I would ask that all of you recognize that this is being streamed to the public, and as such, I trust each of you will conduct yourself in a professional manner. The first thing on our agenda is the approval of the July 21st, 2020 meeting minutes. And for my board members, if you've had an opportunity to review those, do we have a motion to approve them?
I move to approve.
I second.
Okay. And board members, after you make a motion or you approve or second anything, would you also state your name so that there's no confusion amongst which one of you has seconded something?
Bud Potter approves, or move to approve.
Matt Ward seconded.
Thank you very much.
Thank you. All right, under old business, there's none. And under new business, that brings us to this evening's appeal number 001-AP-2020. Appeal filed by Joel and Catherine Weitzel at 1328 Beach Lake Drive regarding 1316 Beach Lake Drive under 502.03 regulations dash fences, walls, and hedges. Anyone that's going to testify either in favor or not of this appeal, please raise your right hand and repeat after me. Do you swear? Actually, don't repeat after me, just answer yes or no. Do you swear to tell the whole truth and nothing but the truth?
I do.
Yes.
Mr. Riley, you as well, please, if you choose to testify.
You.
I do.
Okay. All right. So we have the Whitecells and the Rileys that have been sworn in at this point, right?
And myself and John Canty.
And John Canty. Okay. All right. So there's no confusion on that. All right.
Kyle and Aaron McKee if needed.
Hello.
Okay. All right. Well, I think at this point, Beth, do you feel, do you want to give a brief overview of the appeal or not?
Just, yes, I'll try and do this as quickly. Excuse me?
Excuse me, before you- the meeting, you clarify everyone is participating.
I'm sorry, I can't hear you.
Would you repeat who has identified themselves to testify?
Well, everyone is participating, the board members, the trustees, who's in attendance on this meeting is being identified.
The people who are sworn to testify are you and Mr. Weitzel, Mr. and Mrs. Riley, myself, zoning inspector John Canty, and Mr. and Mrs. McKee if needed. Do you want me to go ahead and continue?
Yeah, Beth, if you just want to give a brief overview of the appeal, and then we'll get into the testimony.
Okay, sure. This is in regards to a property located at 1316 Beach Lake Drive. The property belongs to Mr. and Mrs. Riley. A fence permit for this location was approved by the Township's zoning officer, who at the time was Robin Fuller. The zoning inspector determined that the fence complied with the provisions of the Township resolution after an inspection. Mr. and Mrs. Weitzel are the neighbors of Mr. and Mrs. Riley, and they are asking to appeal the inspector's decision. Mr. and Mrs. Riley purchased the property at Beach Lake Drive in January 2020 and requested a permit through the Township office, which, as I said, was approved. The COVID outbreak delayed the inspection, but in June, Mr. Canty did inspect and found that the fence complied with all the provisions of the resolution. Mr. and Mrs. Weitzel, whose property abuts that of the Rileys, submitted a request for the appeal. Mr. and Mrs. Weitzel turned in an appeal, which is detailed in their letter, which has been shared with all board members and has been made available online for everyone. There were several different points being made, which I have responded to with Mr. Canty's assistance. Do you need me to go through those various points?
No, I don't need you to. I think that's sufficient, and I think we can get started here to keep this moving along.
Okay, if you don't mind, Chairman, I would like to point out a couple of things at point 7, just so for further clarification. And that is that the Weitzel's contend that Mr. and Mrs. Riley's fence is not a split rail fence. I just want to present to the board that in the past, the township had 2 types of fences, a solid and a split rail. In January 2020, the board of the zoning commission included an apron fence. So for residentials, we have 3 types of fences, a solid, which most people would consider to be a privacy fence. We have an apron fence, which is detailed as being a framed fence with decorative wire in the middle. And then we have the split rail fence, which is tending to be, if you Google it, which I believe I have provided some of those pictures, can be anything from the old Western style fences to the type that run through the neighborhood that are similar to Mr. and Mrs. Riley. That's the only thing I wanted to, I didn't really expand on that in my summary. I just want to make sure that was clear here.
Okay. All right, well, why don't we call on the Weitzel's to make your case.
Okay, first off, I was wondering, Ms. Beatty referred to her pictures. Where are those pictures? I just noticed the email with the updated documents about 2 minutes before we walked out to the car. And I couldn't access them. So I don't know if there are documents out there that we have not been able to view.
Just 1 second. So most of the pictures, several pictures were in my summary. I can share my screen real quickly to show you. Let's see here if I can get to it. Just 1 second. Okay, you should be able to see this is the apron fence, which I spoke of, related to the new zoning amendment. These were images of split rail fences through a Google search. And additionally, I did, as noted in our summary, my summary, we did have internal discussions, which the people that were involved in those discussions did determine that the Riley's fence was considered a split rail fence based on our zoning code. I'm done.
Thank you.
Thank you. We ready to go for Karen? Is that unmuted?
Yes. Chairman, are you ready for us to go forward?
I'm ready, yeah. If the white cells, are you ready to keep testifying and present your case for the appeal?
Yes, hopefully. We keep losing audio or whatever on here, so please keep that in mind, whether this can actually be a conducive meeting scenario or not is debatable. Okay, so before I begin, can you hear me?
What? Somebody keeps muting us.
I can hear you now.
I thank you.
I really don't see how this is going to work. Okay, so the email that Ms. Beatty sent out this morning with additional documents, I'm assuming someone is going to present that because we have not been able to review that. We were not aware that those were being distributed, as I said, until right before this meeting. I do want to, first of all, thank all of you board members for your service and for the time to review and hear our appeal. We really feel it's unfortunate that we are here because we think this should have been avoided or could have been avoided if the township had been responsibly carrying out their duties. If you read the reason we stated for filing this appeal, you will know that we aren't going down this path to lash out at our neighbors. We do feel obligated to hold our township officials accountable, not only for our sake, but for the sake of all our neighbors and the future of our neighborhood. There appears to be a recurring tendency for the zoning department to not apply the regulations as written. And we know people have become victims of it, and now it's come to impact our property. I wish I could share with you some of these specific cases. I feel I can't say anything that potentially identifies these people because they don't want to be identified, especially since it's being recorded and streamed. We have lived peaceably at our current residence for over 24 years. We have never had conflicts with our neighbors, and our neighbors have never indicated they have had any problems with us. We are not ones to publicly draw attention to ourselves or our actions to assist and befriend others in the neighborhood, but we're not going to get on that path here either. But if you have any doubts about our character or what it's like to have us as a neighbor, please ask those who live near us and have known us over the years before you let whatever unfavorable rumors you have heard recently influence your ruling on this matter. We have lived with many situations in our neighborhood that might not have totally or dealt with, but we have never been one to rat out others or harass them in any way. That is as true today as it was the day we moved in. Over the years, we have contended with neighboring issues as a result of the fact that some people have had situational and personal struggles. We try to be tolerant and we do what we can to help out without reporting violations. But now when the township illegally enables the violation of our zoning code and as a result creates a new situation that impacts our property and its value, we decided we can't sit by and be the victim. In the light of the way the township referred to us in their report, and because of the apparent occurrence of chatter among township officials, we feel it's important for you to be familiar with how we got to where we are today and our initial efforts to be accommodating. The night of January 12th, families came to our door and introduced themselves for the first time. They wanted to know if our fence was theirs. We had a nice chat where they found a property marker. We gave them our phone numbers and told them if they ever needed anything, not to hesitate to let us know. They told us of their fence plans, which was a low 2 or 3 rail fence of the same type the contractor had on his property, but lower. Please excuse me, my mouth is very dry and I'm in a car. I originated the suggestion that there might be a possibility of their mesh on our fence. We would need to consider and discuss it between ourselves. The next day from a neighbor's property, we checked out the contractor's fence and how he attached it to a neighboring fence. A neighboring property owner had drawn our attention to this fence before, and this review affirmed the unfavorable impression we previously had. We decided we did not want potential damage to come to our fence or the resulting difficulty for performing proper maintenance on our fence. Although we're not able to do it this past fall and have not been able to do it yet this year, you might be amazed, but my husband actually scrubs our fence and water seals it regularly. So in the pictures you see now, it's not at its best, but it will look better when he hopefully gets around to it as this matter is resolved. So we also knew there would be issues that would come due to animals that would be near our fence, ground maintenance, and the unknown of any future property owners if the Rileys were to relocate. We did not want to denigrate the contractor's work to our new neighbors, so we simply texted in such a way as to ask the Rileys if they would want to meet to view the fences in that area and discuss other options. They replied they were going ahead with their fence. At some point in the next 2 weeks, several pallets of lumber appeared in the Rileys' driveway and sat there for nearly 3 months. We later realized the lumber was there for over a month before the permit was issued. We never heard anything further from the Rileys regarding the fence. We started to think maybe they had changed their mind and might be waiting for the contractor to come get the lumber. Saturday, April 11th, Easter weekend, without any prior courtesy notification or request for permission to use our property, we were awakened to the sound of the crews starting work on the fence. When we saw where the fence posts were going in, my husband went out to discuss from a distance the plan for the fence. Keep in mind, this was during the lockdown. He was unable to get answers relevant to his question from the crew, so I texted the Rileys asking to meet across the backyard where we could maintain appropriate distance and discuss questions we had about the fence. They did not reply via text. Mr. Riley showed up at our door. My husband stepped out on the porch to speak with him and expressed our concern about how close the fence would be to our property and the Rileys' ability to maintain the ground in the fence. Mr. Riley said he knew it was his responsibility, but it seemed he hadn't considered all the seasonal and other situations he would have to deal with or thought it through as to how he would do so. Meanwhile, the crews continued to use our property, including our garden areas, despite permission. We did not say anything to prevent them. Easter Sunday evening, my husband and I put temporary low garden fencing and netting on as much of our garden in that area as we could. We still didn't say anything regarding access to our property or forbid them. Monday morning, the crew started work and saw the protective measures we took. They came onto our property while I was outside in the yard. All they said was, quote, "Can we at least come onto your grass?" End quote. I will admit, I really wanted to say no, but I thought that would just be mean. So I told them they could only be on the grass and not in the gardens. I informed my husband they had asked permission, to which he thought I said, but we did not say no. We were supposed to go. A little bit later that morning, I was advised by someone with knowledge of property and liability we should allow them on our property for liability reasons. I didn't want to go out again, but I went out and said to the crew, and this is what I distinctly remember saying this: "I'm sorry, I know I told you that you could be on our grass, but I've just been advised for liability reasons we shouldn't allow it, so you have to get off our property." The one gentleman said, okay. The other gentleman continued to use his power tools and construct the fence. At that
We lose them.
Can you hear us? Can you hear us?
Yes, we can hear you. Keep going.
Okay. So you see, we tried to give them as much consideration as we felt comfortable without risking liability or jeopardizing our property. We feel the township's response submitted for this meeting seems to shed a bad light on us, blaming us for issues related to the fence by us not allowing the contractors on property. We're telling these tried to be accommodating. We tried to be proactive to bring up to their attention things they might not have considered, but it was to no avail. Once the fence was completed, we did have concerns. We had read the township code regarding fences that was available online, and we requested and received a copy of the zoning application and permit and current zoning regulations. On April 21st, we submitted a list of concerns to the township and asked the township administrator to share it with the inspector. And we said we would like to speak with the inspector prior to the final determination, but we did not hear from the inspector or the administrator. We followed it up again on May 21st, and we were told the inspector would be made aware of our concern during a meeting May 26th. We really had hoped the inspector would take the proper action once he was made aware of our concerns. We didn't want to make a big deal of this. We just wanted things resolved. We did not hear anything further, so we followed up again on June 7th. On June 15th, we received notification via email from the township administrator that the inspector had signed off and the fence passed inspection. She also informed us we could file for an appeal within 30 days if we chose to do so. Via email, we asked the township administrator what was required to submit an appeal, and we asked that we be provided information as to what the appeal process would be. She emailed us a list of information we would need to provide. She said after we submitted our request, she would review it and schedule a meeting with the board. It seemed like a simple enough, cordial process. She never told us the township would put a big sign in the Riley's yard, or that they would publish in the newspaper or send letters to the neighbors. Nor did she refer us to the section of the township zoning regulations or the Ohio Revised Code that requires such things. We really were not out to make a spectacle of the Rileys or ourselves. This was just all kind of hit us in the face. We recognize that the Rileys have a right to construct a fence on their property, but they also have a responsibility for it to be compliant with the township zoning regulations. The township also has the duty and legal responsibility to only issue permits for applications meeting the regulations and must do so in accordance with the Ohio Revised Code. They also must make sure the completed project is compliant before granting final approval. Mrs. Riley stated to us on more than one occasion prior to the construction of their fence that they would comply with all zoning regulations. Unfortunately, the township, by issuing an illegal permit, did not conduct this process in accordance with the law and has resulted in a fence that is not in compliance with the regulations. I thank you for allowing me this time to give you this background information. I know you may think this is not necessary as your duty is to simply rule on the appeal. But in light of what has occurred surrounding this case, I felt it was important
Before we comment on the township's response, provided in document called cover letter, would it be permissible to have each board member indicate whether or not that they thoroughly read and reviewed prior to the meeting our request for appeal and the photos we submitted?
Yes.
Mr. Chairman,
Yes, that's fine. I thoroughly read every page and exhibit that you presented on both sides of this matter.
Could you please identify yourself?
I'm Tom Francis, the chairman of the board.
Mr. Chairman,
Okay, I'm sorry, we don't recognize voices.
Tom, it appears the power is back on. They may be able to get a better connection from inside now.
Okay.
Are you willing to wait?
Do you have more to say? Have they completed their testimony or not? Do we know?
No, we have not completed our testimony.
Okay. Do you want to try to get back inside and see if you've got power?
Yes. Yes, I would prefer that.
Okay, well, go ahead and check it out.
Thank you.
Yep.
Can you hear us?
Yes.
Thank you for your patience and being so accommodating to us.
Well, that's fine. Get yourself situated and make sure you're comfortable, and we'll get on with it when you are.
So I believe we left off where the chairman had confirmed he had read all of our appeal documentation.
8 pages, correct?
Sounds about right.
Yes. I not only read it, but I highlighted much of it.
Thank you for all your time.
Bud Potter, I read the materials thoroughly and also highlighted parts of it.
Thank you.
Matt Ward and I did the same.
Thank you.
Okay, thank you. Appreciate it. Okay, so again, this is from the township's response document, and since they address things kind of by what they refer to as point one, kind of summarized it. So point one says relating to the location of the fence on the west property line. It says the township requires the submittal of a survey that is drawn to scale and that shows the exact location of the proposed fence. The survey submitted by the contractor indicates 1 inch equals 25 feet. Using that scale, it is clear that under the permit, the fence along the west side line, which is our property line, is 3 feet inside the property line. Okay, so if you look at their application, or if you would look at photo number 3 on the survey form, you will notice that it says it's inside there. The application of the permit is also evident by comparing the markings for the fence on the west side to where the fence is indicated along the east and north property lines. The east and north markings are right at the property lines. The west is 1/8 of an inch inside. The applicant for the permit signed a statement which reads, applicant agrees to be bound by the provisions of the zoning resolutions of Perry Township, Franklin County, Ohio, and by the terms of this application. Therefore, in order to be compliant, the fence must be located 3 feet, approximately 3 feet from the west property line. Why does the township require a survey drawn to scale and require exact location of the fence to be indicated if the survey is not followed and the fence can be arbitrarily placed? Okay, the township replied one statement for points 2 and 3 about the soundness and safety. Twice the inspector approved a fence with 2-inch wires protruding from it, staples sticking out and mesh gripping away from the wooden portion of the fence. We see the Rileys have made some improvements regarding these issues since the second inspection. But due to the location of the fence, they cannot maintain it properly, as evidenced by the fact that the fence still has some wires and staples protruding. There are also work boards still held in place by one nail. To document this, we have added photos taken earlier today. And if Ms. Beatty would like to share those on the screen, there's photos number 17 through 22 on our Google Drive, which the link is embedded inside our initial appeal document. Ms. Beatty, do you want to show those?
She's muted.
I know she's muted, but she can
Yeah.
screen share and display this information. And while Miss Beatty is looking for that to share that, I'll continue. We still believe a post sitting in an anchor is not properly set in order to be sound. The anchor box is to be in the ground, not on top of it per the instructions by the manufacturer. The other posts in the area may help and support it in line, but over time is likely to become an issue if not addressed. Okay.
Miss Beatty, have you been able to find that link? You're muted.
Okay, we'll continue. Point 4 per the response document, title or reference fence not properly finished. We ask you to consider, why do you think the contractor put finishing boards on the fence facing the street? Photo 23.
Oh, she's going to these first.
If you want to go back to photos 17 through 22, please.
He's here.
Yes, those were taken today.
You can see the wire and the board not attached.
Oops, sorry. Let's see if we could just go back. All right.
18 is another portion of wire that's has sharp edges on it. More through photos 21 and 22 as well.
Can you just do 17 and then just do the arrows to click through each one, kind of like a slideshow?
Thank you.
You see at the top and down the side. Staples. This board probably isn't going to hold up long. And also there's still wire.
Okay, those are taken from the west side of the property that's adjacent to us. Okay, do you want to go back and also show photo 23, please? To indicate the finishing boards are up front. If you notice, you can't see the cracks where the boards and things were put together, but that's done on the front. That's where the gates and things are. Okay, why does the township require a supporting post to be on the owner's side? It's aesthetics. Is it not also the best view appears to the neighbors and to the street in order to preserve the aesthetics for the community? Without the fishing boards added to all the posts, we certainly do not get the best view of the fence. On Powell Road, the fence around the sheep and llama pastures have such finishing boards, as do the horse corrals in Jewett. We would like to think Perry Township and Worthington Hills should have aesthetic standards at least as high as local animal pens. Okay. Points 5 and 6 about maintenance of the fence and grounds. If the fence could be properly constructed from the owner's
Could not.
Excuse me, if the fence could not be properly constructed from the owner's property by a fence crew, as the township states in their reply, why are we now to accept that it can be properly maintained going forward by anyone who may or may not have experience with fences? If a fence can be properly maintained, then why are there still work boards with one nail and wires and staples still protruding after 2 inspections? If the fence can be properly maintained, then why did the owners in April leave a note in our mailbox stating, quote, "We'd like to stain the side of the fence, but to do so, we need to stand on your property," end quote. Our concern about the owner's ability to properly maintain the fence and the grounds extends past the current owners. The current owners are the 4th family to occupy that property in the past 6 years. None of the previous owners left under conditions they had expected. Maybe the current owners will go to the effort to use their trimmer, and maybe they will figure out some way to clear the leaves and debris under the fence. We believe the Rileys have good intentions. But what about the next owners? The fence often remains for decades, and things like this generally do not improve with age. The consequences and repercussions of this fence are a reality we have to live with for the rest of our lives, or at least while we're at this property.
So then we have point 7, which is the wire mesh and the split rail fence. You already read the fence company's definitions and other community rules, such as Old Stone Crossing, which we provided to give examples of the customary meaning of a split rail fence. Every dictionary source available that has the same definition for split rail, and they use these words: fence rail split from a log. None of them use any words such as board, plank, sawed, milled, lumbered, or nailed. Doing a search for split rail fence on Lowe's and Menards retailer websites, the results are only rough hewn or rough cut logs and notched posts. If Miss Beatty, if you'd be so kind as to show us photos 24 and 25 A and B, we can see those search results.
One moment. (24)
24, and then go on to 25 A and B as well. I believe 24 is the search results from Lowe's, and 25 A and B, I believe, are from Menards.
Oops, sorry. Sorry, it's on my screen, but it didn't share. Okay. All right, here is 24.
So if you do a search for using the terms split rail fence and select wood fencing, there are only 6 products that come up. If you do it Menards and do split rail, you get 15, which they also include gates and some material list as part of their products, but otherwise they're all rough hewn and notched post. So a true split rail will generally only have one dimension, a length. Sometimes it will include something called a girth, which is the measurement around the middle, similar to a circumference, but it does not have a width or a depth. If the zoning officer is somewhat knowledgeable about building products, which I would expect him or her to be, the officer would have immediately known the contractor did not plan to build a split rail fence, because on the application he listed, quote, fence boards 1 inch by 6 inch by 8 feet treated lumber. The split rail and more fence store, which if you look at photos 26 and 27, identifies itself as a local family-owned business in Lancaster, Ohio. You'll see a clear distinction between lumber fencing and split rail fencing on these. So this is a pine split rail and a nail on board. In our immediate neighborhood, we reviewed a total of 110 properties on Beech Lake, Candlewood, and Clubview surrounding Beech Lake. Up until about a year ago, every fence that was wood with wire mesh in this area was a split rail fence, meaning rough hewn with notched construction. If Miss Beatty would please screen share photo number 28, we can see that map. You will see on this map, green indicates split rail fences, rough hewn with notched construction. There are 11 that have wooden fence with wire fencing joining them. You'll also see indications on the properties to the right and left of 1316 Beech Lake. These have sections of split rail fences as landscape features. The two properties on the map fully outlined in red are the contractor's property and the Riley's property. The partially outlined in red is a property that also has a lumber and nail construction fence with wire mesh. Although it has post caps and finishing boards on the post, making it appear a bit more suitable in the style for this area of residential properties. We do not know if maybe they had a variance, since it seems the effort was made to fit in with the neighborhood. It's relatively new fence that I believe was installed this spring or summer, but I do not recall a township hearing sign ever appearing on this property, and it's an area I walk multiple times each week. The fence does not appear on the Google Street View if you search that property, and I believe that Google Street View was updated in this neighborhood last year. When the current zoning regulations were proposed, the people of this township were provided the zoning regulations for review. It did not simply say rail, it said split rail. Those words mean a specific type of rail fence. The people of the township were agreeing to a regulation that would provide some cohesiveness. And it appears prior to this year, and except for this contractor and the zoning officials, people in our neighborhood who want to have a wire mesh and wood fence know what a split rail fence is. I don't mean to be offensive, but it's ridiculous, and it should be somewhat embarrassing for the township that the zoning department's defense of their errors is to say they did a Google search and an informal office opinion poll. I did a Google search using my grandmother's name. The search turned up images of women who may have the same name as my grandmother, so they may be a valid type, but it also turned up images of men, mannequins, tombstones, stores, and other inanimate objects. Just because an image of a lumberboard corral fence may have appeared in their search results does not mean that is a split rail fence. The creator of a website may have set up tags and metadata to generate more hits for their website. A multi-word search, such as, quote, split rail fence, end quote, may and does often result for a match in returns for a match on any one word, such as fence. In a Google search, an image may be displayed that is not at all a match for the full combination of the search terms.
Continuing, when the Ohio legislation passed Ohio Revised Code Section 519.17, which says, quote, no such zoning certificate shall be issued unless the plans for the proposed building or structure fully comply with the zoning regulations then in effect. They say fully comply. The Ohio Revised Code also lays out a very specific process a township must follow to amend its zoning codes. This does not say the zoning officers can eliminate whatever qualifying words they choose or ask whoever may be in the office on a Wednesday morning to establish their own customary meeting. By issuing the zoning permit for 1316 Beech Lake, when the list of materials provided on the application were not the appropriate materials for a compliant fence, Perry Township violated Ohio Revised Code 519.17. Although we did not request a document for the fence on the contractor's property, we suspect this violation also occurred on the contractor's fence permitted a year or so ago. This would mean a pattern of what seems to be negligent, or illegal activity by the zoning department is being established. The township zoning officials have now approved an illegal fence at 1316 Beach Lake twice. They signed off on the certificate twice with issues still in violation of the zoning regulations. If this appeals board establishes the precedence by allowing this fence outside the zoning code to remain, it will open the door. We feel it will open the door for that precedent to be used in the future in place of actual regulations. This would basically render the zoning regulations useless. Township residents then will have no way to know what is and isn't permitted, and will have no chance to appeal if they believe the fence is non-compliant. What is decided by this board may be a one-night decision for you. You will all log off your computers and forget about it. But the repercussions of it are a reality we, my wife and I, will have to live with the rest of our lives or suffer consequences of marketability and value of our property should we have to relocate. If you allow this approval to stand and the fence to remain as is, then we sit on our deck and patio, porch and our sofa, and we will have a view of an illegal fence, and we will know it is illegal, which will make it even more offensive. The township officials and this board will have violated the trust of the residents of this township and abandoned their responsibilities to the people of Perry Township.
Thank you for your listening.
Is there anything else either one of you would like to express?
Do you have any questions, or will we have an opportunity to have a rebuttal?
Well, I think with the extent of other folks that are going to be testifying, I don't know how long we're going to, we don't want to be here at midnight, obviously. So I think if there's anything else you have to say, now is the time to express it. And fully make your case. We're giving you ample time to do that. So if you're done, we're going to move on. If you're not, I'll give you a little bit more time.
We believe we have presented the facts and in an accurate and truthful manner. And we also hope that people do realize that this is not a vendetta. It's not anything personal. It's holding our officials accountable and protecting our property. That's all it is. That's all it has ever been. Thank you.
Okay, thank you both very much for your detailed appeal, both in writing and both of you testifying at length.
Mr. Chairman, this is Jen Huber. If I can interrupt just a second.
Sure.
The photos the Weitzel's provided, and only because I don't want to forget, I want to remember it now and not forget. Do we want to introduce those as admit those as an exhibit or as exhibits?
Yeah, was it photo number 24, I believe?
He had 17 through 24, 25 A and B, and 26 through 28. Is that correct, Mr. and Mrs. Weitzel?
We also referred to a couple others specifically that we had previously submitted, but I don't believe she screen shared them. One moment, please, and we'll find the number for them.
One was 13.
13 was one of them.
13 shows the fence extending, or their fence extending past their stuff and attached to our fence posts, as is the neighbors, the appropriate or behind.
And those would have been submitted because those were submitted with your appeal documentation. Those are part of the record. And you're more than welcome to explain as much or as little as you'd like. I wanted to be sure that the photos you introduced today went onto the record as exhibits. But again, you're more than welcome.
Yeah, no, that's fine. We also had photo 3, but those are all on the same Google Drive. Please be aware that that is controlled by me. So if these are needed, you need to either contact me to find them and get them in another way to store them. If you cannot do that, because at some point in the future, I'm probably not going to leave these pictures out on my Google Drive forever.
Understood. We'll make a copy of them for our file.
Thank you.
Okay, so Mr. Chairman, do you want to just give the whole 17 through 28 as Exhibit A, or do you want to give them consecutive letters or numbers? Totally up to you.
I think just as they were, it was 17 through 24, 25A and B, right?
And then 26 through 28.
Yes.
All photos dated August 11th, 2020. Okay, so make those Exhibit A.
Yeah, let's make that exhibit.
For me. Okay, that's it for me.
Excuse me, does that need to be by roll call vote?
No, they were submitted as evidence and they're deemed admitted. We just wanted to make sure we gave them a letter.
Okay, moving right along. Do the Rileys wish to testify at this time?
Yes, we do.
Okay, you have the floor.
Thank you. We will make this short. As we stated in our appeal, we really believe that the heart of, or I'm sorry, in our response, we believe the heart of the White Cells appeal is the fact that we put up a fence at all, and they are angry that we have quote unquote ruined their view. There are many different definitions of split rail fencing. I think Ms. Whitesale and Mr. Whitesale chose what fit into their own idea of a split rail fence. As Ms. Beatty showed, a simple Google search will show many different designs. The neighborhood of Worthington Hills has many different designs of split rail fencing that have been approved in the past. We applied for a permit explaining exactly what we were doing. It was approved, and then the fence installation was approved, and then it was reapproved. Honestly, we would just like this to be over. It has been a long process. We love the neighborhood. We're first-time home buyers, and we really would just like to enjoy our backyard and our fence in peace. Do you have anything?
Nothing much really to add on this. I just want to further the fact that I think it was evident from the start, especially with the text message that we admitted, that the Whitesales simply didn't want us to put in a fence. They claimed that it would ruin their view. And I think the basis to their entire argument and this entire appeal is because we put in not this style of fence, but because we put in a fence at all. And that's all I had to say.
We are curious about what the end goal is for the Whitesales filing this appeal. Is it that they want the fence removed? At the end of the day, we have 2 dogs and we hope to have children. So there will be a fence, if not this one, a different one. So we're just confused about the goal of all of this, to be honest. But we appreciate your time, and I think we've laid out a thorough response, and we respect what you all do. So thank you very much.
Yes, thank you.
Okay. John Canty, are you prepared to testify?
First, Tom, do you want to, just in keeping with my interruptions, do we want to admit, did the Rileys submit a document, and do we want to admit that as an Exhibit B?
Yeah, we should if it hasn't been submitted already. They submitted a response that was 4 pages. And rebutted the 7 points that were raised by the other party. And they had a total of exhibits A through F, A, B, C, D, E, F. Exhibit A was a recap of some texting between the two parties. Exhibit B was 11 photographs from within Worthington Hills of similar, very similar fences. Exhibit C was where they cut the, trimmed the wiring so that it's flush and not sticking out. Exhibit D was explaining a fence post and why it was secured as a result of the tree and the root system. Exhibit E had to do with the PVC being stapled flush with the fence. And finally, Exhibit F were some photographs of the western side of the fence and how they're showing how they plan to maintain that strip of grass between their fence and the neighboring fence.
Okay, Mr. and Mrs. Riley, do you want to go into any further detail on those documents? And you don't have to, that's up to you. And or do the board members want the Rileys to go into any further detail?
We're happy to answer any questions. I feel as if we've thoroughly laid this out in our response, and there's no reason to read through it again. We trust that the board went through all of the documents ahead of time.
Okay, I have no further questions of the Rileys. Should we move on to John at this point?
Yeah, that'd be great.
Okay.
Okay, I'm John Canty. I'm the zoning inspector. As Beth has outlined, this permit was approved in early spring. I don't remember exactly when, by Robin Fuller. Shortly thereafter, we were furloughed due to the COVID outbreak. I came back on June 2nd, I believe, and in the interim, the fence had been constructed. And I went out and looked at the fence. I don't recall the exact date. I'm going to say maybe June 10th, something like that. And I found that it met our code. I didn't find it lacking in any respect. I think that the document, the response that that Beth gave, which addresses the Weitzel's arguments point by point, pretty much take everything into consideration. It was found to be structurally sound. They can trim the grass that's on the west side of the fence without going onto the Weitzel's property. I don't believe there are any issues with the fence.
This is Bud Potter. I have a question for John. John, the pictures that we saw earlier from the Weitzel's there did show that some boards were not attached or only partially attached, and that the fencing, the metal fencing, was not attached in places. Did you see that?
I did notice, I think there were, I'm not sure if it was one or two. Beth Beatty and I went out and looked at the fence. We actually stood on the Weitzel's property to look at the new fence. And we did notice there were a couple of boards that were, like I said, one, maybe two boards that were only attached with one screw. When I asked the Rileys about that, they said that that's the best that the installers could do, because they had to reach over the fence to try and put the screw into the board. The wire netting was, for the most part, was attached securely. There were a couple of places that I pointed out where it probably should be resecured, and I believe that the Rileys have done that.
Oh, I believe the Weitzel said that they took those pictures today.
I couldn't see the Weitzel's new pictures very well. If they showed that the fencing was not secured well, I couldn't see that on the presentation just now. I was able to see that I think there was one board in that slideshow that only had one screw attaching it, and that's probably the same one that I took a picture of.
Okay, so it would be relatively simple though if they had access to those boards to attach them. Is that correct?
If they could get on the west side of the fence to firmly attach, it would be much easier than trying to lean over. I suppose the contractor can come back and once again try and lean over the fence and attach it that way if they don't have access to the west side.
Okay, if they had access, they could do it.
Correct.
John, this is Tom Francis. Just to recap a few points here, the fence is all within the Riley's property, correct?
As far as we can tell, yes.
Based on the survey that we have and based on what you could see.
Right.
And it is structurally sound and secure, I assume?
Yes.
Okay. And I think just to recap too, back on February 23rd, when this was all proposed and submitted and I believe originally approved, the materials for this fence were clearly disclosed on the survey of being 4x4 by 8 foot treated post lumber for the fence posts to be set in concrete. And the fence boards were 1x6 by 8 treated lumber. And then that black PVC coated wire fence. And that's what was originally approved based on what was submitted. And that's what currently was installed and exists there today. Is that correct?
That is correct, yes.
Okay. So it is your position that there is no violation?
Yes, that is my position.
Okay. From my board members, are there any further questions before I make a motion?
Yes, I have a question.
I have a question.
Okay.
This is Bud Potter. My other question is that the corral type fence is permitted by the code. Is that correct?
Yes, it is.
Yes, it is. It's under 502.031. I believe is the number that I'm reading or I've read several times.
Okay,
So,
yeah, I don't have that in front of me. That sounds correct. I know it's in the 500s.
Okay, another question I have is in that same area is that it says that vinyl clad plastic or PVC fences in colors black or green used in conjunction with a split rail fence is permitted. So is that vinyl clad fencing permitted with a corral style?
Our code doesn't address corral fences at all. In our code, we call them either an apron fence, I believe is what we added most recently, and a split rail fence. And I think there's a reference to a privacy. But there's no mention in the code specifically of a corral or a ranch style or board on, there's so many different ways it could be described that we believe that split rail just covers it's kind of a generic term that just covers the entire spectrum of those types of fences that you can see through, that have posts obviously in the ground, that have horizontal boards attached to them, whether those boards are 1x4 or whether they're have some dimension to them. And you could say that they're, more of a rounded look to them as opposed to a flat board. Our code does not make a distinction in that.
I think it does under number 1. It says open fences, partially open fences and hedges are permitted in any required yard. So it doesn't describe the exact materials, but that would be a
Right.
partial fence.
Right. Yeah, it's an open fence.
So that way, that corral type fence would be permitted there.
Pardon me?
It seems to me that a corral type fence is covered there.
Is covered, yes.
Under
Yeah.
there, and it's a common fence within Perry Township, I believe, fairly common. So,
Very, very common. There's many examples of that style fence.
right, but the code itself does say, and it limits it, the way the code is written. Technically, I believe it says, and maybe the attorney can help us out here, vinyl clad plastic or PVC fences in colors black or green used in conjunction with a split rail fence. Says that's permitted. So, but it's also permitted with an apron type fence. So I think technically speaking, I don't believe it's supposed to be attached to any other type of fence.
John, it's Tom again. Do you have Exhibit B by chance that the Rileys had submitted? And that showed the about 11 photographs of similar design
Yes.
style fencing
Yeah,
with the wire.
Yeah, I have to look in the right stack here. I know I've got it here.
And I believe these are all from within the same community of Worthington Hills.
Yes, correct.
And from what I can see, I haven't physically been at those properties, but from these photographs that are pretty clear, they all to me look like the same construction as what they have.
They're all very similar, yes. And many of them you'll notice have the wire mesh attached to them as well.
That's where I'm leading. Doesn't that by itself set a precedent within that community that this is an acceptable style of fence?
It's been an acceptable style of fence as long as I've been employed by the township, yes.
Okay. So the term split rail, there's different variations or interpretations of what a split rail fence is. There's a traditional split rail that we saw on the other exhibits from Lowe's and the other source. But then again, when you look to other sources, there's also the style that we're seeing in Exhibit B here.
Yeah. There's like I said, there's a broad range. Depends on. I don't know it depends on how someone wants to describe a fence. I don't know that there is a scientific exact name and description for a split rail versus a corral versus a ranch style versus any other style of fence, apron fence, anything else that you want to put out there. I think that
so based on the historical fences that already exist in this community that appear to be the same design, regardless of what you want to call it.
Right.
That isn't that precedent that these must be acceptable. And I would assume that's the basis of why you've approved it too, right?
That's correct.
Okay. Are there any other questions from the board members of the inspector?
Well, I got a comment. I mean, as far as just reading through the different types of fences, I think this easily falls within the apron fence. I mean, this is 4 feet tall, is it not? Or is it taller than 4 feet?
It's about 4 feet tall. Yeah.
Yeah. I mean, it appears to me based on the picture that we show in the code and the description, apron fences that are solid wood framed with welded wire fabric shall be permitted. So I think it easily falls within that category. And then as far as the wires that are clipped and not, the pictures that they showed, I mean, is that you, John, that says that those need to be fixed, or is that someone else? I mean, I would assume that the Rileys would want that taken care of just from, if I paid for a fence, I'd want it done correctly.
Right, and it should be pointed out that all of those wires are on the Riley's side of the fence and not the Whitesell's. And as I said before, I did speak with them about several places where it could be attached a little more securely, and they assured me that that would be done.
Right. Yeah. I mean, it certainly seems like it's a contractor's punch list that they could come back and have that taken care of. And I think they would want that taken care of because I mean, it's brand new and you want it to be brand new.
Right.
And then as far as the one other question, I guess from the post anchor, I saw the pictures of it. It seemed like it was anchored. I understand from their response, it was due to the tree roots and what have you, and trying to minimize damage by digging post holes. Was that secure and appropriate for the application?
Yes, it was secure. I guess I would add that it's something that they might want to keep an eye on as the years go by. But for now, it is secure, and I don't see any reason why it shouldn't be in the future. And if for some reason it becomes insecure, we could address that with them at that time.
Okay.
Mr. Chair, do you mind if I say something here?
Oh, go right ahead.
What I did want to add is that the apron fence, the inside is a decorative metal fence. The mesh that's being used in the Riley's fence is a vinyl clad type fencing. So that's one of the differences between the so far as the apron fences. It's decorative, it's got design to it and so on and so forth, and it's just a metal inside.
But the mesh that's used it's vinyl coated metal, correct? I mean,
not in an apron fence.
Well, I understand. Wait. But it's not, when we say vinyl clad plastic PVC, that's even with the split rail fence, that's included or inclusive of it's welded wire fabric with a vinyl coating versus just a welded wire.
Correct.
Right.
Okay, are there any more questions at this time?
Yeah, I've got a question. This is Matt Ward. I've got a question. John, between the two sections that describes apron fence and the vinyl clad split rail, do you agree or not that there's some ambiguity as to exact definitions there and what's intended from the zoning commission? Because in lieu of a definition, the BZA can only interpret what's in the code, and in lieu of a specified definition, we can use the common accepted definition of split rail fence, which is split lumber or split trees. Do you think that adds some confusion there and needs to be cleaned up?
I suppose, like many laws that you might look up on Ohio Revised Code or elsewhere, yes, it could probably use some clarification, and we could go through there and specify the 27 different types of fences that exist, and I made up number 27, and perhaps we should in the future, just to be more clear. We never anticipated that this level of detail would be ever litigated.
You may just want to take out split rail and leave in fence.
The other option is to just say fence and not even go into all the details of the 27 or 58, whatever different types of fences there are. You're right. That might be the ultimate solution.
Jennifer, I have a question for you. Do we, as the BZA, have the ability to interpret a definition of what split rail is? Try to define what the zoning commission meant, or do we have to use the commonly accepted definition here and let the zoning commission define it later?
Matt, you can weigh all of the evidence in front of you and sort of like a judge, put, as you always do, put weights on what you're hearing. I think there is a basis for the BZA tonight, or when it makes its decision, to go either way, to either read, I mean, on the one hand, I'm just playing devil's advocate on both directions, to read it literally and decide that what has been installed is not a split rail fence, that the fabric has to be the way that the vinyl clad plastic or PVC fencing has been used, it would be required to be used in conjunction with a split rail fence, and that this is not a split rail fence. Alternatively, the BZA could determine, based on what you've heard tonight, that what you're looking at, based on the totality of everything you're looking at, that it is a split rail fence, and that the decision of the zoning department was reasonable and under all the circumstances and all the evidence that you have. If that clarifies it at all.
Okay, so if we would turn this down because it's, let's say, we don't consider a split rail fence, the property owners have the ability to come back and ask for a variance, and we could be back doing this again next month. Correct?
They would have the ability to ask for a variance. They would also, as you've heard tonight, have the ability to just take off the PVC coated fencing that
Wire mesh.
Yeah, thank you.
And I understand that, but if they're going to have small dogs out there,
sure,
you probably want some type of.
Absolutely. And yeah, practically and legally, they would have the ability to come back before this board and ask for variance. Yes.
Okay, thank you.
You're very welcome.
Are there any other questions?
I'm not sure if it's a question, but we just had a couple thoughts we wanted to throw to the group when it is appropriate, Mr. Chairman.
Yes, go for it.
So my name is Kyle McKee. This is Aaron McKee. We live directly behind the Rileys. We moved in last June, and when we moved in, we basically had kind of the old raggedy chain link fence running through the back. And we were excited to hear that the Rileys are going to put in a new fence because I think it was a huge upgrade from what we did before. So we actually also chipped in to have the back part, or the chain link fence, the back of our property removed when they were adding this fence. And I can speak for my wife and I say, we absolutely love it. We think it looks great. And it's a huge upgrade from what was there before. So I know that's not a legal stipulation or standard, but it is our preference that the fence remain in place how it is now.
Okay, thank you. Board members, this is the last call. Anything else before I make a motion?
Go ahead.
Chairman, do you want to hear from well, I guess I should ask, is there anyone else, in attendance who wants to provide testimony? Okay, well, maybe that silence is my answer.
Okay, all right. Okay, well, before I make this motion, board members, whomever seconds the motion, be sure to state your name. And then I will have Beth do a roll call of each board member for the final vote, including myself. After careful considered judgment of both the testimony and the documented facts that include 11 examples of similar type fences within Worthington Hills, I will make a motion that this appeal be denied. And just to clarify, if you vote yes, that's a denial of the appeal. Beth, will you proceed with the roll call?
I will.
You want a second?
Oh,
Yeah.
yes, a second.
Do we have a second?
Matt Ward seconds.
Okay, I'm sorry. And Beth, will you now proceed with the roll call?
Yes, sir. Mr. Francis,
Yes.
Mr. Ward,
Yes.
Mr. Potter.
Yes.
I'm sorry, you're Mr.
Yes.
Potter. Thank you. Mr. Deisler,
Yes.
Mr. Kent. Mr. Kent.
Doesn't look like he's on.
He was on.
Miss Jen, my understanding, it's the majority of the board. Is that correct?
Yes.
Yeah, so you still have a quorum if you have 4 of your 5 members, and you have a unanimous vote of that quorum of the 4. So you have 4 of 5, and you don't, because it's not a tie or anything else, you don't need that 5th member.
Okay, thank you.
Okay, well, that concludes the hearing portion of our meeting. Do we have any additional reports tonight? Any announcements?
One second, I'm trying to get back into my agenda. There we go. Oh, I just wanted to let you know that we had put out an advertisement online in the newspaper, e-blast, for another board member since Mr. Carr has retired. I will be getting together with the Board of Trustees, going over the information that we did receive from people who are interested. And we will hopefully have that on the Board of Trustees agenda for an appointment.
When is that meeting where they vote on that?
It would be this coming Monday.
Okay. And do we have 2 candidates, I believe, at this point yet?
I've received 4 different resumes today.
Okay. All right. So by our next hearing, we'll hopefully have filled that position for the additional alternate.
Correct, for the alternate, yes.
Okay.
The only other announcement or update I have for you is Mr. Canty anticipates having a BZA meeting again in September. I believe there are potentially 3 variances to be heard that evening. And that information will be forthcoming.
Okay. All right. Well, I think with that, I'll make a motion to adjourn.
Matt Ward, I'll second the motion.
Okay. Thank you all for your participation.
Thank you all for your service tonight. Much appreciated.
Thank you for your time.
Thank you.
Thank you, everyone.
Yep.
You have to keep their